2/3 majority. That's all the argument is left with. 2/3 से कर लें, ठीक है. आपका एक वोट कम है, आप नहीं कर सकते हो.
That's what
it boils down to that.
Sir, my lord, to defend, protect, and preserve the constitution. If the constitution
for the people of Pakistan,
if that is the thing, then
फिर हम आपसे वही सवाल पूछेंगे कितने लोगों ने किया है इसको.
Then constitution gives a mechanism, a procedure. You can, my lord, with utmost respect, it is not a numbers game. It is a constitution put. The premise said that if a constitutional amendment has to be made for the people of Pakistan, because they are representing where the independent judiciary will be fully secured, then you have the number games. It is the constitutional requirement.
You were not agitated enough either to vote in to have filed your own petition. No, you have filed your own petition.
No,
or
sir.
you're on notice.
Notice, sir.
So you were not agitated enough to have filed your own petition. Some people came and filed their own petition. So if you were so agitated, you should have done it the very first day yourself. The Supreme Court, it would have been very nice to see Supreme Court Bar Association.
जो cases file किए वो तो take up नहीं हो रहे जो Supreme Court bar
वो क्यों नहीं हो रहे take up? क्योंकि आप ये केस को खत्म ही नहीं करना चाहते.
बात नहीं है सर.
खत्म करें.
Election petition pending.
The Constitution says we
the people of
ये
Pakistan.
Excuse me, जरा हमें भी question करने का time दिया जाए.
Give ourselves the following Constitution.
जी.
Now, the people of Pakistan have said, if we want to amend the Constitution,
जी.
we would do it through our
चलिए ठीक है, ये argument हो गया, आगे बढ़ते हैं. चलिए ठीक है, समझ गए 3/4 का argument. चलें आगे बढ़ें.
Mr. Zuberi,
क्या मैं सवाल कर सकती हूँ? Excuse me.
जी पूछिए जैसे.
My lord.
जी, the act says that subject to constitution and law, they have amended, they either taken the power of the Supreme Court by making rules. So what article of the constitution they have referred to? They have referred to.
They have referred.
Amendment has been made.
जी.
We are opening the doors.
जी बिल्कुल सही.
In future for amending the constitution.
My humble submission is Article 175.
Simple majority.
175(2) has been read in isolation to amend this law. Basically, an amendment has been done in the Constitution by amended by 175(2). And my humble submission is 175(2) cannot be read in isolation. It has to be read with Article 142A and Anti-55.
अगला point बताइए.
Mr. Zuberi, if I may, Mr. Zuberi,
my lord.
Mr. Zuberi, may I ask you and follow up on what my learned colleague has said, that when Constitution is being amended, it is constituent power that is being exercised.
My lord.
It is a unique power, quite separate and different from the other legislative competence that is available to Parliament. So I think what my learned colleague is saying is, if we open this door of an indirect amendment to the Constitution, we are allowing constituent power. It is not a numbers game, if I may say so, with all due respect. It is a numbers game because it is constituent power. We are allowing constituent power to flow into a channel which the Constitution prohibits directly or indirectly. So therefore, I think the point that my learned colleague has made, that this is at most, or at worst perhaps, an indirect amendment of the Constitution, which is perhaps barred by the Constitution itself.
Sir, tomorrow if this law...
नहीं, tomorrow नहीं, अभी हम यही देखते हैं.
If this law is upheld,
ये बिल्कुल
for
हम नहीं
example,
करेंगे.
then the Parliament can also decide that the junior most judges will...
No. You cannot, we have a particular case, argue that. What happens tomorrow, I am not one who gives judgments on the basis of surmises. इस पे कर लें आप, बहस खत्म कर लिया, आप वही पॉइंट्स बार-बार दोहरा रहे हैं. जरा जल्दी खत्म कर लेना, आपका वक्त निकल जाएगा दूसरों का.
You are representing the Supreme Court Bar Association. You are not a petitioner nor respondent. क्या आप ये बेहतर नहीं था कि आप आके कहते हैं कि जनाब इस एक्ट को पेश करने की जरूरत क्यों महसूस हुई? मेरे ख्याल में जरूरत इसलिए महसूस हुई कि हमने 184(3) के पावर्स कॉन्स्टिट्यूशन से हटकर इस्तेमाल किए. क्योंकि अगर आप इसकी वर्डिंग पढ़ें, उसमें सिंपल बात यह है, फिर से अगर आप पढ़ लें, मैं पढ़ता हूँ आपके लिए. विदाउट प्रेजुडिस टू द प्रोविजन ऑफ आर्टिकल 199, द सुप्रीम कोर्ट शैल, if it considers that a question of public importance with reference to the enforcement of any fundamental right conferred by chapter 1 of part 2 is involved. हमने जो ऑर्डर्स किए, हम तो लोगों को सजा भी देते हैं, हम लोगों को बरी भी करते हैं, चीनी की कीमत भी मालूम करते हैं, बहुत सी चीज़ें करते हैं. क्या ये अगर हम अपने इस डोमेन में रहें तो किसी लॉ या रूल की जरूरत पड़ेगी? मेरे ख्याल में नहीं।
सर आप सही कह रहे हैं, लेकिन मेरा ये नहीं है ये मैं कह रहा हूँ कि जी ये आप पावर बिल्कुल आप सही कह रहे हैं, गलतियां की होंगी, लेकिन पार्लियामेंट उसे सही नहीं कर सकती इस लॉ के थ्रू। दैट इज माय केस। अगर आप करेंगे तो आप खुद करेंगे सर, ये अपने रूल्स में अमेंड करके सर।
इसका मतलब कॉन्स्टिट्यूशन से बढ़कर पावर
नहीं, आप अपने रेगुलेट करेंगे अपने रूल्स और प्रोसीजर को। गलती अगर आप कहें तो आप उसको करेक्ट करें, आप उसमें रूल्स अपने रूल्स अमेंड करें, उसमें आप
अच्छा चलें आबिद ज़ुबैरी, you are repeating yourself. अगर हम किसी और को मौका देते हैं, you just repeat. नहीं, do you want to if you're repeating yourself, we'll ask here someone else.
184(3) is original jurisdiction
जी.
conferred by the Constitution,
जी
and it is the original jurisdiction. And if appeal is given, that would continuation of the proceeding before the original court.
जी
This is settled
you
law.
will have a super
It is settled
Supreme
law.
Court. जी
Any provision of the Constitution where appeal is given by a simple legislative power by the Parliament, that is permissible under the law.
No, my lord, under the Constitution it is not, sir. That's my, and may I just quickly take your lordship?
Zuberi Saab, how would you explain enlargement of jurisdiction?
Yes, I'm coming to that.
And conferring supplemental
Yes, my lord.
powers?
जी
Because you see, to be interpreted liberally
जी
as already laid down by this court.
number of cases, sir. My lord, humble से एक बस एक आप करके फिर खत्म
नहीं, आप
करूंगा
directly उस पे आ जाए ना.
जी.
If the
सर
parliament
मैं
is
कह रहा हूँ कि जी
competent to
पार्लियामेंट
enlarge the
सर कोई
jurisdiction
जी enlarge
and also to confer any supplemental
yes
power.
my humble submission अपील जो पार्लियामेंट ने दे दी इसके अंदर, तो कल किसी चीज को भी अमेंड करके सुप्रीम कोर्ट को दे सकते
नहीं,
हैं.
आप देखें ना, पहले इसको तो जरा
रूल
kindly
50
explain कर दीजिएगा.
anti-50
अगर तो वो jurisdiction expand कर सकती है पार्लियामेंट, तो फिर उनका इख्तियार है.
नहीं सर, with utmost respect sir.
So how do you read
जी
this?
I'm reading, I'll take help from a judgment of this court, 2000 SCMR, page 567, and the relevant portion is at page 617, sir. And let's read this paragraph to answer your lordships and my lords. 2000 SCMR, page 567, Province of Punjab is the National Industrial Cooperative Credit Corporation. इसमें through a provincial law, appeal was provided to the Supreme Court. That was struck down. Though a judge or cooperative judge was a judge of the Honorable Supreme Court, that was said that is fine. But when the appeal was granted, it was struck down. And this is what the Honorable Supreme Court had. My lord, kindly see page 617, para 17.
Page 6.
617, my lord. Starts at 567 and page 617. And the appeal के बाद may I just read? The lordship page. Coming now to the present Constitution of 1973, it may be of the para 17, sir. It may be observed that according to the Learned Counsel for the Government of Punjab, in view of Article 175(2) of the Constitution, under which jurisdiction can be conferred on any court, including the Supreme Court, by or under any law, in relation to matters in respect of which provincial legislatures have power to make laws, including cooperative societies, additional supplemental jurisdiction or powers can be conferred on the Supreme Court by provincial legislatures. The law mentioned in Article 170 includes a provincial law and additional supplemental jurisdiction on powers and form an appeal to the Supreme Court under Section 22 of the impunity laws being conferred on the Supreme Court in respect of a matter which the provincial have exclusive jurisdiction under the Constitution to enact laws. Now, since judgment is quoted and the finding of the court at the bottom of the page. In view of, there is no ambiguity interpreting entry 55 or part 1 of Federal Legislative List 4 Schedule of 73 Constitution. Entry read with Articles 175(2) and 142A of the confers exclusive powers on the Parliament to make laws for enlargement of the jurisdiction of the Supreme Court or conferring on its supplementary powers. If entry 50 was not there in the Federal Legislatures, it could be argued that under Article 175(2) of the Constitution, in respect of matters relating to corporate societies exclusively falling under the comprehension of provision, a law can validly be made by a provincial enlarging jurisdiction of Supreme Court and conferring on its supplementary power. But Article 175 is not to be interpreted in isolation. It has to be read and interpreted along with Article 142A and entries in the legislative list. Under entry 55 of the Federal Legislature is competent to make laws regarding jurisdiction.
Actually, you're not reading the relevant part. The relevant part are two lines.
जी.
The last is 616 पे last line पढ़ लीजिए, and the two lines following that. That's what is the answer to the question. 616 की last line पढ़िए page पे.
जी, from the aforesaid.
हाँ.
From the aforesaid entry, it follows that under the interim constitution, additional supplementary jurisdiction could only be conferred upon by a law made by. ये sir interim constitution की
आप
बात
पढ़
कर
तो
रहे थे.
लेना, provision तो वही है ना,
जी.
by a law by the federal legislature.
नहीं सर,
वहाँ इशू सिर्फ इतनी सी थी. जरा समझने की कोशिश करें ना.
सर, मैं 73
आप जरा सुन तो लीजिए ना हजूर, कि वहाँ सिर्फ ये बात उन्होंने कही कि जी सूबाई उसको पावर नहीं है, और स्पेसिफिकली ये जुमला इस्तेमाल कर दिया फेडरल लेजिस्लेचर कर दे, तो वो प्रोविंशियल बात तो हम भी मानते हैं. मतलब मैं कम से कम मैं तो बिल्कुल आपसे एग्री करता हूँ इस बात पे.
उसकी एंटी 55 में एनलार्जमेंट की बात नहीं की हुई थी.
एक
72
मिनट, ये
के.
आबिद जुबैरी साहब,
जी, मैं इसको पढ़ लूँ सर प्लीज.
मिस्टर आबिद, एक मिनट, मैं आपसे उसके 4 लाइनें पढ़ लीजिए, उससे पूरा जवाब आ गया. इसमें 618 पेज पे आइए,
आ रहा हूँ उसी
फर्स्ट पैराग्राफ
जी,
लास्ट 4 लाइंस हाउएवर से पढ़ दीजिए आप.
सर मैं यहाँ इसके ऊपर भी बड़ा
वो
इंपॉर्टेंट
पढ़
है.
दीजिए, वो
इसका आ रहा हूँ जो माय लॉर्ड्स क्वेश्चन वाज.
अच्छा, फिर आप फिर छोड़ दीजिए. फिर अगर आप समझते हैं आप शाम तक चलाएंगे इस
नहीं
केस
सर,
को,
बस मैं ये
सुबह से
पैरा
आपको
पढ़
दे
रहा
रहे
हूँ
हैं
ना सर, ये
टाइम.
2 लाइनें
आप ये हाउएवर से पढ़ दीजिए ना.
लंबे लंबे पैराग्राफ पढ़ेंगे.
दैट इज द क्रक्स. हाउएवर से पढ़ दीजिए.